hacked phone, a drained bank account, a fake link, beware. You could be just a click away from a cybercrime. In India, such crimes are on the rise and many victims don't even know how to report them. So let's talk about India's cyber laws. How strong are they? Do we need new ones? Hello and welcome to this segment. I'm the host. First, let's understand what we're dealing with. Cybercrime. It includes online fraud and phishing, identity theft, hacking, cyberbullying, ransomware attacks. The list is long and the damage is real, and it doesn't just affect individuals or companies. Governments can also fall prey to cybercrime. So what do our laws say? In India, the primary legislation dealing with cybercrime is the Information Technology Act 2000, the IT Act. But that's not all. Relevant sections of the Indian Penal Code, the IPC, and the Bankers Book Entry Act, the BNS, are also used. For example, cheating under Section 420 of the IPC, impersonation under Section 419, theft of data under Section 378. These laws have been in place for a long time. Let's look at some key provisions in the IT Act. Section 66C deals with identity theft. Whoever, by means of a computer resource or a communication device, dishonestly or fraudulently, i.e., with the intent to gain or knowing it to be likely to cause wrongful gain, assumes the identity of another person and uses it for the purpose of, i.e., with the intent to gain wrongful gain, such a person shall be punished with imprisonment of 3 years or a fine or both. Similarly, Section 66D deals with online cheating. Whoever cheats by personating another with the intent to gain, i.e., with the knowledge that such act is likely to cause wrongful gain, shall be punished with imprisonment of 3 years or fine or both. Section 67 of the IT Act deals with publishing obscene material online. Section 43 of the IT Act deals with hacking, i.e., knowingly and intentionally causing directly or indirectly any damage to a computer system or a computer network or a communication network which is used by the public or by a group of persons who have access to such system or network. Whoever does so shall be punished with imprisonment of up to 3 years or a fine or both. Now that we know what the law says, let's talk about the problem. Law enforcement agencies are not tech-savvy enough to deal with the rising number of cybercrime cases. Plus, most police stations do not even have a cybercrime cell. The result, victims often do not know where to complain. Also, there are loopholes when it comes to jurisdiction. Moreover, getting forensic reports can be a lengthy process, delaying justice. What's being done to fix this? The Bureau of Police Research and Development, BPR&D, has launched a campaign called BNS or Bankers Book Entry System for streamlining digital crime trials. The BNS aims to improve investigation, prosecution, and conviction in cases of financial fraud and cybercrime. The Bank's Book Entry System, BSS, was launched as its support system. The BSS is a web-based application that facilitates online filing of FIRs related to banking frauds. Recently, the government launched the Cyber Helpline 1930. It is a toll-free helpline that anyone can contact in case of a cybercrime. The Indian government is also working on a new Digital India Act to replace the IT Act. The proposed legislation aims to strengthen data protection and cybercrime laws. The fact is, we live more online than ever before, but our laws are still struggling to catch up with the times. Just like we need smartphones and internet to keep up with the times, we need tech-aware policing, quicker reporting systems, and updated legislation to protect ourselves from cyber threats. Because in the digital world, prevention is truly power. Stay alert, stay secure. This was a special segment on cyber laws. For more such informative content, subscribe to our channel.